Good morning, friends. Now, this is my 153rd video. Now, this is going to cover a topic which I have even earlier discussed, but people keep asking, and so there are new things which come up. And we have a research segment where we give all our inputs to various cases. So once I was making it for one case where the issue had been made, which is very important, which I request, whether the old grand bungalow occupants are owners of the bungalow number so and so, survey number so and so, Mall Road or Staff Road or any Napier or Elgin Road, whatever may be in your cantonment. So what we are basically countered at, if we realize in the last some years, we had some judgments which were countering the admission deeds. But lately, once in the Surinder Kumar Vakil judgment of 2001-2, it was upheld that the GLR is an authentic document. So admission deeds have become very important. So this issue has to be dealt, and it is being dealt. What I am going to discuss today is only on admission deed. Now generally our advocates or by ourselves, we somewhat are not insistent on our pleadings, and if we are not very insistent on our pleadings, maybe tomorrow in the constitutional courts we face this heat of being heard by the honorable judges. Where is the pleading? So we've not, and there we make a mistake. So lower court advocates, I don't blame them. It is the kind of knowledge, it is the kind of expenditure and expectations which we look for. Generally, we build our cases when we are on the foundational platform, and that is the lower court. So friends, please, now this admission deed point will be covering a lot of pleadings of ours and references to the legal sections, which we can pick up, not subjective, whether they would be conclusively in our favor or whether they will go against us. It's a matter of research and matter of knowledge to many other people sitting in this country as well as in either of the 80 Commonwealth countries who've been watching my video, because I do get phones from countries like Australia, Singapore, Pakistan, where there were cantonments and mostly abolished, but in some parts there are. So we need to plead, where is my old grant? Now, if there is no grant being produced, how can, without my grant being produced, my admission deed or my conveyance deeds, which were further termed as sale deeds, have no meaning? Now, where are these written that when admission deed came in, or when was the old grant to be produced, or when was the conveyance deed to be produced as per these laws or sections in various acts written by the Britishers? So we begin with old grant, we begin with the 1836 GGO, which is the Bible, culminating to 1838 also, and there is a prior GGO also of 1833. So the GGO itself speaks that the admission can only be taken if the grant is in existence. It is forthcoming. Second, 1864 Act says all conveyance deeds, the cantonment magistrate has been made the sub-registrar. So everything is in place. Now 1882 TPA Act says all sale deeds, which are still enforced by the Cantonment Act 1924, 2006. So let's read the Evidence Act now. What does it say? 1882, section 114 and 115. And section 43 of the Cantonment Land Administration Rules 1937. So when we try and club into all this, it very clearly says that old grant cannot be presumed. Okay. So this acknowledgement taken on by the department under admission can only be taken if the old grant is forthcoming. So have my predecessors, which I have been saying, sale deeds from 1864 become very important, very vital for you to prove that you were never a new grant under the GGO 179 or either of 260. But bungalow owners yet don't listen to me. So the court may presume the existence of these facts, which it thinks likely must have happened under these sections. Now what does section 114 says? Regarding being had to the common course of natural events, human conduct in public and private business in their relation to the facts of a particular case. 114G speaks that evidence which could be and is not produced would, if produced, be unfavorable to the person who withholds it. Similarly, 114(1) when a document creating an obligation is in the hands of the obliger, the obligation has been discharged. So register of government properties, where are they, in whose custody, needs to be told to the court or to yourself either. So that, once this education reaches you, your scare of being an old grant removes. There is no presumption in law that the entries made in such registers are true until the contrary is proved. The type of presumption which will be found in respect of the entries in records of rights under the law, Revenue Code. So these are various judgments which I'll quote have said. It's talking of P.T. Enclasia, 609 of 1980. Similarly, it talks of an SLP of Purushottam Das Tandon 5931 of 1883. These all were countering the admission deeds. Now we'll come to various judgments on GLRs and Jamabandis. Punjab and Haryana High Court have upheld in 1992 that the change in revenue records without the consent of the owner is not acceptable. Similarly, in the Privy Council, AIR 1935, Lahore, it very clearly read that the Cantonment Records, Journal and Register of Cantonment, the Honorable Judge is stating, I am elect with faith and it should not be placed on them corroborative evidence from other record is a necessary evidence for Journal Land Register. So, go down what I have dug into, another judgment of 2002 under the Punjab Land Revenue Act 1887. Entries in revenue records, change cannot be done without prior notice to the person who is to be affected. Similarly, in 2014, revenue records, Supreme Court upheld, does not confer title. GLR entries cannot be treated as evidence. So, all of us can jumble up more entries like this. And that's how we can. Now, what I just said is section 43 of the Cantonment Land Administration Rules, which states where the condition on which the land is held or hold are forthcoming, and these conditions provide that the transferee shall sign an acknowledgement as to the condition on which the land is held. Such acknowledgement shall be obtained before sanction is given. So clear? Now, the same doing is explained. Very clearly it has been explained in the same book, Cantonment Land Administration Rule, page 254, 255. Admission deed, para B. If the old grant is forthcoming and its conditions provide that the transferee shall sign an acknowledgement, such acknowledgement shall be obtained before sanction is given. But an acknowledgement should not be demanded if the old grant is not forthcoming or if a definite proof of the terms of the grant on which the site is held does not exist. What else? Do we need anything else? So we need to get all this in one place. Similarly, once this act of admission deed is completed by the department, so now under the GGO itself, clause 5, the obligation to produce the grant, where is it? It is written in the Governor General Order itself that all grants to be registered with Quartermaster General along with plan. So where is this document? We don't, we people are so ignorant, and unfortunately, when I did my law, so now I will not blame the advocates or the system up there, because we are not taught cantonment laws. These are special laws. So we need to educate the court either if we are educated. So where is it written? Administrative instructions under the defense states in chapter section 7 subpara 1, subpara 2 and subpara 19. It clearly states that these documents have to be in the custody of the defense state office as stated in cantonment volumes page 1, whether you read it from the CLAs or whether you take it from there. That now if the department, if we can ask them to produce your and my grant and its terms, only then under the Evidence Act section 114 is to be obliged. Somebody needs to, understand these admissions which were taken under 115. Now the department, we must plead a general perception which is under CPC, that is misused, misrepresentations, undue influence, coercion and fraud. Now if we are able to plead and confirm these, then this act of admission being taken or being tendered itself becomes erroneous. Because fraud is something which needs to be proved in the eyes of the laws. So very clearly, once it is there, the Union of India executives, they are then made liable, and this act of liability would actually turn on to become a criminal proceedings against them. I remember there was a case of Landau Cantonment where the Supreme Court had actually ordered in 2010 to produce this old grant of the bungalow. But unfortunately, it never came up and the owner died. So the legal heirs were fighting and things just went away. So we need to understand all this and be very clear on the instructions or laws made by the DGs or the British. They, under a guise of an executive order, will not give us permission to sell or mutate. Let's say if I purchased a bungalow. Till I do not sign this acknowledgement or admission deed, accepting that land belongs to Ministry of Defence under old grant terms, governed by so-and-so GGO. And where is it written? It is written in the volume 2 of chapter 27 of the Cantonment Act 2006. So admission deed is not something which is flowing in. So we must be prepared, to tell the courts, tell ourselves, or even wake up and shake up the executives by writing letters that you people have been asking for admission deeds, you've been forcing these admission deeds on us, subject to these laws, produce my grant and I'll do it. Don't say that because my predecessor gave it. So if my predecessor gave it, you become more obliged to do that. So itself, this entire doing of the department will become erroneous. It will become a fraud. These are private estates, and unfortunately we people, just get flawed by what the department does with us. I'll show you some of the examples, some of these bungalow owners who shared their documents with me, and some came through RTI in Buccleuch Cantonment way back in 1957. The department is not just asking an admission deed, is even drafting a sale deed for the bungalow owner who's purchasing bungalow number 13 there. I remember Mr. Zaki, who's been our vice president, he approached me for bungalow number 80, Barrackpur Cantonment. His bungalow, half is on a old grant, half is on a lease of 1921. So the division of the property, how it took, what has happened, it's so debatable. And then, the Honorable High Court, reasons it back to the DO for mutation, and the DO very clearly in the High Court says that the mutation order cannot be undertaken till an admission deed is not given. This is way back in 2008. So forcibly the bungalow owner is there to give it. Now another case came up with us of Pune Cantonment. This is a grant under GGO 260 of 1938. This is a classic case of admission deed. The GLR speaks of 1938 and the admission deed is being tendered under GGO 179 of 1836. So just imagine, the executives also don't know. What are they asking? What is it? It's just a process which an executive officer or an executive, whether he's a DO or an MEO or a CO, is dealing. So these kind of things keep happening from, and this lady, I remember, both her son and his daughter-in-law are a victim of the 9/11 Taj Hotel. Government doesn't have any relief or any sympathy for you. Another living example came to me. This is of a bungalow in Dakshai. The Quartermaster Journal is way back in 1976 when the CEO is issuing a GLR. How has the bungalow flown in from the predecessor to the bungalow owner presently? So this was a lady who was about 95 years old, and she was willing to, under the 1995 policy, go in for construction. So the bungalow was taken in 1924, and this is how the whole sale deed happened. And so there was no admission deed taken during that period. Now, 1953, for the first time, an admission deed was asked by this bungalow owner, and she was made to give it. And once that admission deed was there of GGO 179, again in 2000, it's very important, the board is again asking for an admission deed. So what are we doing? We can actually, if we read all this, we can nail these doings. Bungalow number 29, Kamptee Cantonment, 2.92 acres. Again, it was like this. The Ministry of Defense and the Quartermaster Journal is writing, we will not mutate the bungalow till you do not sign an admission. If provided, you can go to the court. Finally, there was a civil case filed in 1998, which the bungalow owner finally got that it is a private estate. So contrary admission deeds are being taken by us. So we need to actually, get to our land records and then start off all this. And if this can be done, we will win it.